Okay, so let's get into what we're going to do today is basic estate planning.
We're going to do basic estate planning, and you have the outline. So I'm going to cover, I guess it's about 5 topics here, actually 6. So I'll go through the main categories that we're going to do. One of those is what is an estate? The second topic is why do you need an estate plan? The third topic is what is probate, and I'm going to explain that so that hopefully you will understand that. The next one are the advantages and disadvantages of probate. Then we're going to talk about common types of estate plans. And our last topic is what are gift and estate taxes. And as we go along, we also have a PowerPoint, a slide presentation that will maybe help you understand some of these by pictures. You know, we all learn in different ways. Sometimes we learn orally by listening to a speaker. Some of us learn by reading, and some of us learn by looking at pictures. So we have a slide show that hopefully will be a little bit entertaining and will help you understand this topic. So my paralegal Jackie is going to be running the slideshow, and hopefully this will give you some additional insight into what all of this means. Now, as we get started here, I have to tell you one of my favorite estate planning jokes. And there was a lady who went to see her lawyer about her estate plan, and she said, "I would like to arrange to have cremation." And the lawyer said, "Yes, I can do that, ma'am." And he said, "I would like to have my ashes scattered at Nordstrom's, Bloomingdale's, and Neiman Marcus." And he said, "Well, ma'am, can you explain to me why you want your ashes scattered at Nordstrom's, Bloomie's, and Neiman Marcus?" And she said, "That's the only way my 3 daughters will come to visit me." You didn't like that one?
It rings too true.
So, first of all, you have to know what your estate is to know if you're making one of these mistakes. And one of the biggest things is, what does it consist of? And it's so important to be organized here and to understand that. So if you ever do think about going to a professional, you are completely organized and you understand what the estate consists of. It consists of all your assets. And that means everything from your simple checking account and savings account to your investment portfolio, all your real property, whether it's a vacation home, a timeshare, your personal residence. It includes investment real properties such as apartment houses or strip malls, etc. It also includes all the personal things at your home, which could include your car, your silver, your china, your pictures on the wall, your oriental rugs that you might have acquired over the years, the oil paintings. So all of those things are included in your estate. And the reason this is important is, number one, if somebody passes away, they're all added up, and at that point, the determination is made whether you have a taxable estate, and it does include all these things, including your life insurance. And the other reason it's important is that if you do go to a professional to have estate planning done, you need to know the total amount of your assets so that they can help you if you have a taxable estate and you need to be concerned about any of the taxes that might be involved, which could include everything from income tax to capital gains tax to federal estate tax. So without knowing the full extent of your estate, no professional can give you proper planning. And then I'm a nice person, and there are many nice lawyers, but if you don't explain the full extent of your estate, then the proper planning isn't done, and the children or the grandchildren or your other heirs might sue the lawyer because they didn't do complete planning. But we can only plan for what you have disclosed.
Is there any common asset that's normally missed by individuals?
One of the common assets is life insurance. And this is because people think, oh, they know that there's no income tax on life insurance, and so they think it doesn't really have a value until they die, and so they don't think it's part of their estate. But guess what? Uncle Sam does think it's part of your estate. The IRS includes it. They add everything up, and so it adds to the total value of whatever you think you have. And so even if your main assets didn't become taxable and subject to estate tax, once you add in the life insurance, it might put a real addition on there that would put you over the tipping point, and the estate could become taxable. And then the IRS could take 35%, 45%, 55%, whatever the taxable rate is at that time, and half of those proceeds could go to the IRS.
This is a simple net worth statement, and I recommend it to everybody, that you simply have the assets listed, that you know the title of all your assets, that you have a cost basis, and we'll get into cost basis after a little bit, and that you know the market value. So insurance, for market value, you use the death value. That means after you're gone, somebody gets to spend the money, not you. Okay?
The other very important thing that you need to be organized on is have an accurate list of all your heirs and those people you want to benefit. So of course that includes your children, your grandchildren, and your spouse. But what some people are not aware of, and this is one of those touchy subjects, but we have to bring it up here, that if you had a loved child and, that person hasn't been around for a long time, but you know that child is out there, you have to have that individual disclosed. The reason for that is that if you want to disinherit them, you have to list the name and the fact that they were born, because otherwise they could be treated as a pretermitted, that's this fancy legal term, or omitted child. And they have the right to come back and demand their legal share of your estate if you did not mention it. And that could be kind of embarrassing for the whole family if they suddenly showed up after you were gone.
But with second and third families, does it make it estate planning a little bit more difficult?
Yes, and the issue on that is that if there are second or third spouses and stepchildren, you have to be very careful to identify who you're going to benefit. Where this is a problem with spouses sometimes, if there's a divorce, some of you may forget that that person was on your life insurance policy as a beneficiary or on your IRA account as a beneficiary, and that could be a big shock.
What's the second fatal mistake?
Okay, well, this is a funny little comment. Most people don't just plan to fail, they fail to plan. So why do so many people not do this? 70% of Americans don't do it. And, there's some different answers to that, but, many times, they don't like to think about the fact we're all here healthy today, you were able to come into this room, we're all here, and you think, gee, I'm healthy today, why should I do anything? But sadly, I've run across people even at young ages recently who suddenly dropped dead at the age of 35 or whatever. So you need to have something in place to protect your family, your loved ones, because then the state has a plan for you. And this also involves personal accountability. Accountability for your estate and for your family. The worst cases are people who don't plan. Some of their assets may actually go to the state of California, and that probably wasn't your intent.
Are you going to go through intestate succession?
I am.
Okay.
All right, so the next big issue of why you need an estate plan is incapacity planning. Many people don't take this into account. And one of the misconceptions here, well, all I need to do is make a will. A will only speaks at the time of death. It does not take care of you while you're alive. So there are two types of powers of attorney that you need to have. One is a power of attorney for asset management. The second one is a power of attorney for health care. So what are the consequences of not having a plan? And recently we've heard on TV and the news, anybody remember Mickey Rooney?
Yeah.
He was in a terrible court battle where his two stepsons, and we'll go into this a little more, but you know, he obviously hadn't set up who was going to be his power of attorney for asset management and who was going to be his power of attorney for health care. And because he didn't have these documents in place, the two stepsons got into court and said, "We're in charge." And he said he was robbed, he was ripped off. Here he is, 90 years old, a nice man, and it's the result.
How do you know he was nice? We're just guessing.
We're guessing. We all liked him.
Groucho Marx, same thing happened with Groucho Marx. Yeah. By the way, we're going to spend a whole session on the Advanced Healthcare Directive and the durable power.
But those are two of the most important reasons. We just had a lady, frog in the throat, 94. Never too soon to do your plan. So when we first met with her, she was at a retirement home and her niece was there and she wasn't sure what she had, and they all knew she needed to have these powers of attorney. And so we got them signed within a couple of days because she had a nurse there and they said this needs to get done. So by the time she signed, we made copies, we're ready to take them there. She's already in a convalescent home. And so it's very difficult now for the niece to be able to get to the banks and where she needs to go to get onto the investment account, since this lady waited until just before she was going into the convalescent home. That's why it's so important. Do your planning while you're healthy and while you're aware of what's going on. You can walk in and out of here, and you're all nice people too.
No, they're not.
We're going to go to probate. Probate is the legal process for the administration of an estate. And how many people have ever experienced probate themselves or had a relative involved? So you probably know that this is the legal process where somebody's will or estate planning documents are admitted into the court. And the judge makes the decision on what's going to happen. The first thing that has to happen is that all the debts and taxes have to be paid. The assets are distributed according to the terms of the will, or if there is no will, they're determined according to intestate succession. The proceedings are all public. Now, how many realize that probate starts for real property at a value of $20,000? I used to laugh about this. I used to say, well, if you had a lot in Victorville, you wouldn't have to worry about that. But even in these times, I don't think you can get a lot in Victorville for less than $20,000. Maybe now you can, but So even vacant land that you may not think is a very valuable asset, if it's over $20,000, it's going to be subject to the probate process.
Or overall, what is it, the 100?
$100,000 for all other assets, bank accounts, investment accounts. And how this works, I had a client, a gentleman, 92. His son made sure that his real property, he had a couple of real properties, they were in the trust, no problem. His son didn't know about his bank accounts. So the first time I met with the guy, he was in my office. The second time I met with him, he was in the hospital, but we got all the deeds and everything signed, so the real properties were in the trust. The next thing that happened, the gentleman died. The son came to me very upset. He found out there were 2 bank accounts at the very same bank. They were a total of $105,000. And the bank told the son, we don't care who you are. We don't care that you're the only son. We don't care that you're the only one in the last will and testament, and you're the trustee of the trust. These accounts are $105,000, and you will have to go through the probate court and get a court order before you can have access to these accounts. So the gentleman had to pay $5,000 for probating these accounts, $105,000. Now, some people think that there are advantages to the probate process. And I can think of one situation where there's a big advantage, and this is if the family doesn't get along. The family may have sons and daughters or other members that are very litigious and don't like each other, and they want to sue each other. And so in those situations, it may be very advantageous to just start out in the probate court and have the court supervised, because these people may never agree to settle anything outside of the court anyway. Another advantage is that you have the court completely in charge. So if you think that your sons or daughters or whoever your executor is going to be are not trustworthy, maybe they're spendthrift, maybe they'd like to borrow from the estate and not share it with their brother and sister, it may be a very good idea to have court supervision so the court can make sure everything goes to whom you want it. This gentleman asked, what if your sons and daughters don't get along, you have everything in a trust, and you're afraid they're not going to agree to the provisions? So you put a clause in, if they try to contest the trust, they get nothing. So that's a good question, and there are 2 answers to that. First of all, you have to have the up-to-date no contest clause that was just changed by California law January 1st, 2010. And there are certain new magic words you have to make in the no contest clause to make it enforceable. If you don't have the new magic words, not enforceable. Second point is, who is going to be your trustee? And so you need to make sure that you have an independent trustee, and this may be where somebody like Peter Coates comes in. You have an independent trustee that is not one of the family members and can make sure that the terms of the trust are followed and the provisions for each child.
I love dysfunctional families.
The biggest disadvantages to probate. One of the biggest ones is that it's completely public. And I think we have a slide in here that shows it. It's a completely public situation. And so as we explained with Mickey Rooney and Groucho Marx, those were living conservatorships, when a person dies and they have a will or they have a trust administration or something that ends up in court, everything is public. So either with a will guarantees probate, or if you have no plan, that guarantees probate. And your assets are all listed. There's an inventory, and it's part of the court file. And so your neighbors could run down to the court and find out how much you're worth and what your assets are. Worse than that, there may be unscrupulous people out there who want to sell products or try to do fraudulent acts against the beneficiaries, maybe a surviving spouse who is grieving, or adult children who are grieving. And so at the time of this vulnerability, some of these unscrupulous individuals may want to take advantage when the surviving spouse is the most vulnerable.
Just to put a little different light on it, there's a judge here in Orange County Probate Court, Bumgardner, who says he would never do a living trust because it's not public. Okay? He believes that he's seen so much fraud in living trust because it's private that he will not do it. He will only do a will and public. I disagree with that. I agree more with Christine, but there is another side to that. Okay? So public and private, there's a whole issue of disclosure, etc.
So you can take your pick which way you would rather go.
Exactly.
The other thing is time. And I have seen some estates that take 5 years or more, which is very sad. I had one case where there were 6 siblings, and the parents had done wills when they were teenagers, and that was the last time they did a will, and then they both passed away. The 6 kids were in their 50s to 60s. There was 1 daughter and 5 sons, and none of them could get along. And it was too bad because they had a nice estate of 1,000 acres, and if they had been able to get along, they could have done something with it and made some money. But they were determined they were never going to settle. So we had 4 attorneys involved in it, and the judge forced everybody to sign a settlement agreement, but after it was signed, the daughter has refused to fulfill it. The probate took 5 years, and it's been another 6 years, and it's still not over. So that tells you how long probate can go on. The easy ones may be the shortest. I've never had one that was 6 months, but they could be 9 months, probably, if you're lucky. Average is over 2 years. And so that means 2 years before the heirs get the assets. If there's a family business, the court is involved usually in making decisions. And so if you can imagine a family business being run by a judge, it's a disaster waiting to happen. It may cause the business to go down because each time they need to do something, the court-appointed administrator has to go back to the court and get permission. So it's a very unwieldy process. The judge is happy to appoint attorneys for people who don't have them. And so it tends to prolong the situation.
So for time, you have to file, you have to give notice, there's appraisals, there's accountings, and then there's the distribution.
And then there are the fees. So there are equal attorney and executor fees, and they are calculated on the gross estate. So that means before the mortgages are subtracted, before the debts and bills are paid, before all the costs of the final illness are subtracted. Everything is added up, and the attorney and executor fees are paid on the gross.
And so in a typical $1 million estate, the fees run about
$23,000 for the attorney, $23,000 for the executor, which is $46,000.
and that's not counting the court cost yet.
Right. and there may be appraisal fees, and there may be special, what they call extraordinary fees. So if there's real property involved and the lawyer and the real estate agents have to work on selling the property, they can demand and usually get extraordinary fees.
How many individuals in here have stated that their children can get executor or trustee fees for their work? 1, 2, 3, 4. You may want to talk about this a little bit. I mean, if we're talking about probate, the person doesn't have to take those fees if they don't want to. I encourage people to take the fees because nobody appreciates the work that they have done. What is usually the first question a beneficiary asks?
When do I get my money?
This is my
paralegal.
When do I get my money? That's literally the first question.
Somebody recently, the mother passed away, and right away the daughter, is asking her sister, who's the trust, when do I get my check? We don't even have the death certificate yet in this.
Okay, so talk a little bit about trustee fees and executor fees if you're naming one of your children, so that your other children will understand that this individual is going to get paid. It creates an immense amount of tension within a family. Okay? Now, by the way, even if you have a living trust, you're still going to incur some illegal fees. Hopefully not as much. If you have an outside professional, you're still going to incur some fees. So what is the cost of dying generally? You thought it was free, didn't you? Okay, if you get a cardboard box, that really reduces everything. But if you don't, it's somewhere around 3 to 5% of your net worth. That's an approximate. Okay? So it's not free. There is some cost. There is some liquidity requirements of your estate.
But the advantage here is that the probate costs are going to greatly exceed what it would be if you had a trust. So the advantage of the trust is that it's less time. It can be done privately in the attorney, the administrator, the CPA's office, and it's not subject to public scrutiny or going through those endless court procedures and time-consuming hearings at the courthouse. Question now, this is joint ownership of a husband and wife. Basically, it's called joint tenancy. So in a typical case of a husband and wife, in the joint bank account, yes, the other spouse would get it. But in that situation, it really only postpones a probate. And there are some other disadvantages. If it's in a trust, you get a complete step up at the time of death for capital gains tax purposes. If it reverts to the other spouse without a trust, there's only a 50% increase in capital gains on the half that belong to the decedent. So from a tax standpoint, it's not good. And from a planning standpoint, it may not be wise either, because if it just reverts to the other spouse, worst case, they both die in a car accident at the same time, and then there's a probate on both estates, husband and wife. Other type of case is that the survivor may remarry and pass that wonderful stock and bond portfolio to their next spouse, and then on to the second spouse's children, instead of benefiting the children of the first marriage. So those are the disadvantages of joint ownership, among some others.
Thank you.
So the question is, if somebody dies and real estate joint tenancy property goes to the other joint tenant, is it going to increase? And of course this gets into a technical question. Was it your primary residence? etc. That's one question if it's primary residence. The other one is between parents and children or husbands and wives, it should be exempt from a tax increase. And so there are certain limitations on that, and you have to get consultation on those limitations, but typically between a husband and wife or between parents and children, there's no, it's exempt from the tax increase. Between other family members or non-family members, there would be a tax increase. Okay, step up in basis. Supposing it's a husband and wife. And let's make the numbers easy just for the sake of argument here. We have, say, joint tenants owning $650,000.
A house?
A house.
Okay.
Let's say that as joint tenants, you only get half of the cost basis subtracted. So supposing there was $50,000 cost, only half the cost basis gets subtracted there from the value. Now, if there is no community property, you're only going to get 1/2 of a step up.
So for example, if the joint tenant dies and the survivor is going to sell the property, then their cost basis is $300,000,
Right.
or there approximately. And so when they sell for $650,000, they would they would have to pay a capital gains tax. But each one of us has a $250,000 credit, so we would have to pay a capital gains tax on $50,000 if we had it in joint tenancy. What if we had it in community property with right of survivorship?
In community property, 100% of that $650,000 is stepped up. So it's stepped up from the $50,000 basis up to the $650,000.
So there's no tax when you sell. It is really, and it works with stock, houses, everything that you own. You get a step up in basis. It's one of the major benefits as far as taxes is concerned. The step up in basis rule. So when people put their children on title, the children get your cost basis. Not a good idea. Is another good reason not to use joint tenancy to pass assets on. Because it's a killer from a point of view of income taxes.
In addition, if you transfer it to the children, depending upon what year it is and what the value is, you may be subject to gift tax on the part of the children. You may be making a taxable gift. So if it's more than $13,000 per person, it would come out of your lifetime exemption. And of course, if you're somebody lucky enough to have some multi-million-dollar property, say in Newport Beach, then it may become subject to gift taxes.
What's your lifetime exemption amount this year?
This year, $5 million.
$5 million. And how long is that $5 million lifetime exemption going to be good for in the law today?
That's good until December 31, 2012. And we don't know what happens after that. It's up for grabs. It may go back, if they don't change the law on January 1st, 2013, it goes back to $1 million per person and a tax of 55% on anything over the first $1 million.
And what would be, as a renowned attorney in this area, what would be your prediction as to what will happen?
My crystal ball is broken. I can't predict anything that will happen in Washington, D.C. right now, because until, the last few minutes on Friday night, we're all wondering, did it shut down or did it not? Is the mail going to go out Saturday? Blah, blah, blah. And I work with a charity, and they were actually scrambling on Wednesday because they get funding with local cities and governments, and they needed to get reports in so that if it shut down, they would have all their reports in the computer. So, basic point of this, we don't know what the government is going to do. Joint tenancy means that anybody either on title for real property or for any bank or savings or investment account is also subject to creditors and bankruptcy and creditors of the other person who's put on as a joint tenant. So say you put your son on your home because you think that'll make it easier for him when you pass away and he won't have to go through the probate court process. Unfortunately, your son gets sued. Whoever has the judgment against your son can apply that to your home because his name is on as a joint tenant.
Talk a little bit about beneficiary designations.
The other way that you can arrange assets to transfer without a probate, of course, is beneficiary designations of a life insurance policy, an IRA or 401k, and you can even do it with bank accounts. The problem with all of that is that they are not controlled by your will, they are not controlled by your trust. So some people make these beautiful documents, and I've seen my clients do it. They'll set up either a will or a trust, and they'll say who's going to get what percent, and this daughter's going to get this, and that son is going to get that. And they go ahead and name a beneficiary of their bank account at the bank, and they name a different beneficiary of their life insurance, and they name a different beneficiary of their IRA or 401k. And none of that works together with their trust or will. Once they designate a beneficiary, it will pass by operation of law. And if it wasn't for the son or the daughter that they wanted to benefit, somebody else, maybe even an ex-spouse, is going to get those assets.
So it's really important to understand and know your beneficiary designations. And we're going to spend an entire session on just the consequences of having these beneficiary designations on your IRA, 401k, pension plans, annuities, because they operate completely different. And many of them don't have a step-up in basis rule. Okay? So the person doesn't get that full amount that's in that account. But we're going to spend a lot of time in this area, and it's a complicated area, and we'll have to force you to stay awake because there's a lot of statute and legalese in this area. So, POD, what does that stand for?
Pay on death. That's the bank account where you can simply tell them who you want the beneficiary to be. And if it isn't like the provisions of your trust and will that say 50% to my daughter and 50% to my son, sometimes people name just one daughter when the son thought he was going to get 50%. And sometimes if that happens, those families never speak to each other again. If you name a POD at the bank, your trust or your will have no control over that account.
Real story. Hollywood producer divorces his wife, gets a new girlfriend, goes to the attorney, leaves his entire estate to the new girlfriend, finds out that the properties are held in joint tenancy with the former wife. Who gets the property? The former wife. Joint tenancy, PODs, control, operation of law. So you have to know how you have title to your assets. And many of us forget. So So get a copy.
Question, why would the bank make you do a POD when you already had a trust or a will? You need to get a specific letter from your attorney telling them how you want to have that bank account designated and to make title in the name of your trust if you actually have a trust. And so that's the crucial issue about trusts that we're going to cover. They have to be fully funded in order to be effective.
Remember, a lot of banks don't know the law, and so they go by policy. And if you go to another bank, they'll have a different policy, but you shouldn't be required to do both. Okay? Just like, hey, where do we all learn how to hold title to real property? From our real estate agent. They're not qualified. They don't understand all this stuff, you know, by step up and everything else.
So if it's in the trust, I should take it out of the POD?
Yes.
Correct. Absolutely. A lot of tellers just don't know, and you shouldn't expect them to know.
So the key point here is don't let those professionals you work with tell you how to take title to your house, how to designate your accounts, or how to designate the beneficiary of your accounts if you have a trust and a will. They should be coordinated with the trust or the will, and you should be getting legal counsel from your attorney on that issue.
Is living trust a way to hold title to assets?
Yes, a living trust is a way to hold title to assets. And so again, the benefit here is that a living trust is not public, and it can be administered very quickly once somebody passes away compared to how long the probate. So the living trust sets up title. And the reason that the living trust is so easy to administer is because title carries on after you die. People don't understand that the reason that a will does not carry title on and has to go through probate is because you're gone. But if you set up a trust, you name the trustee who is going to hold title for the benefit of your beneficiaries, and that person can carry on and doesn't have to go to court to get permission.
So just to review, probate avoiders, living trust, if you have an amount under $100,000 just in your name, $20,000 for real estate, joint tenancy, community property, beneficiary designations, POD, insurance, your IRAs. Those are all probate avoiders.
So the advantages of the living trust is that it avoids probate and your assets must be transferred and named in the name of the living trust. And usually your attorney will give you a certification of trust that has the proper title. And at our office we have letters prepared for people to take to their bank, their investment advisor, their life insurance as to how beneficiaries should be set up and named to be the living trust. If you have a lot of life insurance, there may be a separate, you may want a separate trust for that, but that's the subject of another seminar. The trust controls who receives the assets, and that's why it's so important to have them titled in the trust, because the trust will benefit those you love and not the people you don't want to benefit.
There's a question.
Yes.
Are you talking about the insurance policy outside of your trust?
In some cases, there's a tax reason to have the insurance policy separate from the trust. So that would be dependent upon your total value and whether you have a taxable estate or not. So there's a different strategy for holding insurance proceeds if you have a taxable estate.
Almost a reason for people having to pay estate and gift taxes is because they didn't do the proper planning. You can get your entire insurance policy out of your estate and not have it be taxable if you go to an estate planning attorney. I want to just kind of go through a little bit as to the types of wills that are in existence.
Yes. We have something called a holographic will. And many people think that's the answer to all their problems because they don't have to go to a lawyer and they don't have to pay any fees. If you're going to do a holographic will, it has to be all in your own handwriting. It's written out in your handwriting, it's signed by you, it doesn't have to be witnessed, and it should have a date on it because the last holographic will is the one that's supposed to be followed, and if you change your mind, you shouldn't have several different wills with different dates, without dates.
And it's the most litigated form of a will. And you can see why. You know, it's because it's handwritten in the person's own handwriting, and sometimes people don't write real clearly as to what they want to have happen. So consequently, Howard Hughes, was his written will upheld?
Still
No.
being litigated.
Is it still being
I
litigated?
think parts of his estate are still being litigated.
Wow. Okay. Stay away from holographic unless you're in a bar and absolutely need to change your mind. Write it on that napkin. Okay. Statutory.
Statutory is provided by the California State Bar and the Probate Code, and you have to, again, you can sometimes get it at a stationery store or you can download it from the California State Bar website, and it has certain provisions. You have to fill in certain parts, you have to sign your name. There are 2 witnesses required, and you have to follow the rules exactly or it will not be upheld.
It's the second most litigated form of a will. Avoid it because nobody is completely like all you have to do is fill in the blank. And so people do cross out words, and as soon as you do that, it's no longer valid. What is a formal will?
The formal will is what most attorneys prepare, and that's the one that's usually very nicely done on a computer or typewritten. You do have to have 2 witnesses who have to follow certain rules and be present at the time that you sign it. Usually it's initialed on every page, and that states your name. It usually includes your marital status, and that's where you list all the children, whether you want them included or not. They must be listed if you want to disinherit them, because otherwise they could be considered an omitted or pretermitted child.
Remember, even like a will and a living trust, when you're thinking about this, one of the things the attorney is going to ask you is, what if one of your children were to die? What would you like to have happen? Would you like to have it go to your children, to your grandchildren? Do you want it to go to that wonderful spouse? What do you want? But in a will or a trust, those are the kinds of questions you are going to ask. Is that correct?
That's correct. So we always want to benefit the children, the spouse, and do it the way you want, so that everything is very clear.
By the way, the 2 witnesses have to witness your signature. If this doesn't happen, the will is invalid. I had a situation where the testator forged one of the witnesses' signatures, causing the whole thing to be invalid, and the estate went intestate.
The other thing that has to happen is that they both have to sign at the same time. They both have to be there. They have to see you do it. And if somebody is incapacitated, can't sign their own name, it is legal to make an X, but then one of the witnesses has to write next to it and say they saw that person make the X and that was such and such a person.
What is a pour-over will?
The pour-over will works with the living trust. The reason you have to have it is so that if some assets accidentally got left outside of the trust and they don't pass by operation of law, if they can be poured into the trust, $100,000 or less, real property less than $20,000, the pour-over will says put it into the trust. Of course, if the assets are over the limits, there will be a probate.
Talk a little bit, we didn't talk about intestate succession. What does it mean and what happens?
Intestate succession is where you are one of the 70% that has no trust or will, you never signed anything, and you pass away with no trust or will. And this is where the state of California has a plan for you, and they say how much goes to your spouse, how much goes to your children. It's kind of, if you have a spouse and one child, it's 50-50. If you have more than one child, the spouse gets a third, the children split up 2/3, and then they go down from there with their who inherits. And the surprising thing is that stepchildren, foster children, all kinds of children are included in the definition of children. And then it also goes to relatives who may be in-laws, etc. So if you don't want one of those pictures like we showed up here, the nightmare heirs, you need to make sure that you have a plan so that the state of California doesn't say what your plan is. Worst case, all the assets go to the state. Last point on witnesses for the will. They should not be a son, a daughter, a niece, a nephew, or a spouse who's going to inherit. Because when you have what's called an interested witness, that can invalidate the will. Then it's considered that the person was under undue influence, fraud, duress, all those terrible things. And so you need to have two disinterested witnesses who are not going to inherit from your estate.